Hello there, I'm attorney Kelly Longtin from Kelly Longtin Law, and I want to thank you for watching this video. Today we're going to talk about bankruptcy's effects on estate planning. Bankruptcy may be one of the last things on your mind when you're creating an estate plan. Fortunately, the number of bankruptcy filings has declined over the past several years, but there's still a whopping 544,000 bankruptcy filings that occurred in 2020, and clearly those numbers rose again in 2021 due to the pandemic. So what happens to your estate if you file for bankruptcy protection, but you die while still going through the bankruptcy process? And what if none of your beneficiaries or one of your beneficiaries is in bankruptcy or is soon likely to be? Now, none of us knows what the future holds, so you should consider these important issues in your estate plan, even if the possibility of bankruptcy seems far-fetched right now. So let's begin by talking about what happens to the estate if you're in a bankruptcy when you pass away. Now, a will enables you to leave specific instructions about whom you would like to receive your money and your property and how you would like for it to be distributed when you die. However, in general, your debts must be paid before your beneficiaries can receive a single penny from there. And as a result, if you're in bankruptcy when you pass away, your beneficiaries will receive only what is left of your life savings and property when the bankruptcy case concludes. Now, individual debtors typically will file for Chapter 7, which is a liquidation, or Chapter 13, which is a repayment plan bankruptcy. If you pass away during a Chapter 7 bankruptcy, the bankruptcy case will proceed without much of an interruption because your direct participation is very limited after the meeting of creditors. The bankruptcy trustees will sell your property, including your interest in non-exempt property that you own jointly with your spouse, and in community property states, all property acquired during the marriage, to obtain cash to pay off your creditors. However, certain properties such as motor vehicles, clothing, household goods, and retirement savings accounts is exempt because it is necessary for living and working. Now, when the bankruptcy case concludes, any remaining money or property can go through the probate process and be transferred to the beneficiaries that you have named in your will. Chapter 13 bankruptcy involves a repayment plan that typically lasts from 3 to 5 years. So you as the debtor must actively participate in the plan by making those payments. If you're in the midst of a Chapter 13 bankruptcy when you pass away, your bankruptcy trustee and your survivors usually must petition the court for instructions about what to do next. Typically, there are several possible courses of action. They can first request that the case be dismissed, enabling your creditors to seek repayment of debts in and through the probate proceeding. Second, they could petition for a hardship discharge, eliminating the obligation to continue to repay the debt, even though the repayment plan was not completed. Third, they could request that the case be converted to a Chapter 7 bankruptcy filing so that the estate can be liquidated until all of the debts are discharged, or they can continue the case as a Chapter 13 bankruptcy, with your heirs attempting to complete the repayment plan. Although the bankruptcy trustee and the survivors can request a certain course of action, the court will ultimately decide what's in the best interest of all of the parties that are involved. So let's talk about some solutions to all of this. First is if you want to protect your savings and your property against potential future creditors, consider transferring them to an irrevocable trust. You will not be able to easily amend or cancel the trust, but because you no longer own any of the property or the money in the trust and you have no right to change its terms, the accounts and property in the trust generally cannot be used to pay off creditors, even if you file for bankruptcy in the future. As a result, your money and your property will remain available for future distribution to your beneficiaries. But I just want you to be aware that this strategy will not work if you knowingly transfer money and property in order to avoid debt. So it's important to implement this strategy proactively long before any financial problems leading to bankruptcy arise, because you must disclose to the bankruptcy trustee any transfers made within 2 years before filing, and the trustee will review the transfer to evaluate whether it should be undone, making that property or money available to your creditors. Now, some states allow an asset protection trust, a special type of irrevocable trust that is self-settled. That is, the person who creates and funds the trust is also a trust beneficiary. There are numerous details that an experienced estate planning attorney should consider when determining whether this type of trust will protect your money and property if you eventually file for bankruptcy. Now, transfers of money or property to this type of trust made within 10 years prior to the bankruptcy filing are vulnerable to being undone by the bankruptcy trustee. So let's talk about what happens if one of your beneficiaries is in bankruptcy when you pass away. If you die within 180 days after your beneficiary files for bankruptcy, then you must disclose the inheritance to the bankruptcy trustee. In a Chapter 7 bankruptcy case, unless the property is exempt, the trustee is free to take the inheritance to pay off your beneficiary's creditors. If the beneficiary has filed a Chapter 13 bankruptcy, the value of the inheritance, except for any exempt property or money, will be added to the amount available to the beneficiary for repaying creditors under the repayment plan. So, for example, it will increase the amount of the payments that your beneficiary must make. Another solution you have when dealing with bankruptcy is that you're free to amend your will to eliminate all gifts to a beneficiary who has filed or who might file for bankruptcy, to avoid having all of your hard-earned money and belongings used to pay off creditors rather than being distributed to the beneficiary that you named. Now, many people dislike this option, however, because they don't want to effectively disinherit someone. Often it's their child whom they want to actually benefit from their estate. Now, one of the best ways to prevent your life savings and property from being used to pay off a beneficiary's creditors is to create a revocable living trust. Now, you can transfer ownership of your money and property to the trust and retain complete control over and enjoyment of your property during your lifetime. Now, because the trust and not the beneficiary owns the property, and because the beneficiary has no legal claim to the trust assets during your life, and because the trust can be revoked at any time prior to your death, the property will not be considered to be part of the beneficiary's bankruptcy estate. In addition, money and property held in a trust with a valid spendthrift provision specifying that the beneficiary cannot transfer their interest in the trust and has no control over it typically cannot be used to pay off the beneficiary's creditors in bankruptcy. Now, after your death, your beneficiary can receive distributions, meaning gifts from the trust, according to the terms of the trust, as long as they are purely at the trustee's discretion or for certain specific purposes such as health, education, maintenance, and support. However, any amounts distributed prior to the bankruptcy or within 180 days after the bankruptcy petition has been filed can become part of the beneficiary's bankruptcy estate and be used to pay off creditors. Now, a standalone retirement trust that is drafted as an accumulation trust rather than a conduit trust can be used to protect the funds held in your individual retirement account or other types of retirement accounts, so whether it's an IRA or a 401k, from being taken by creditors if your beneficiary files for bankruptcy after your death. Now, because inherited IRAs, in contrast to the debtor's IRA, are not protected in bankruptcy proceedings, it is necessary to provide additional protection by using a trust. The trust is funded for your retirement account upon your death, because the trust is irrevocable. Those funds are protected from the beneficiary's creditors. Now, we can help you plan ahead. It's impossible to know what the future holds, and those who are prospering today may encounter financial problems tomorrow. So you don't want to wait until you or your loved ones are experiencing money troubles or even the prospect of bankruptcy to take action to protect your life savings and your heirlooms and your property that you've worked so hard to accumulate. Now, we can design an estate plan that will help you protect your money and your property and your loved one's inheritance. So please feel free to give us a call today to create or update your estate plan to ensure that your estate is protected from creditors' claims, whether or not you have a loved one who ever even files for bankruptcy. Sometimes it's good to put these protections in place so they're there just in case they're actually needed. So I hope you all found this beneficial, talking about bankruptcy and how it affects your estate plan. I'm attorney Kelly Longtin from Kelly Longtin Law.